Public Safety Committee to order. I've asked our very own Senator and Reverend Kim Jackson to give us a word of prayer. Senator.
Thank you. Let us pray. Gracious and loving God, we pause this day to give you thanks for this day, for the opportunity to gather with one another to make decisions that impact your people. We pray especially for those men and women who are in uniform, for those who watch over us day to day as we travel the highways, as we go about our business, and for those who are abroad, who care for us and watch for the safety of our nation and of this world. We ask that you would be with the families of all who serve in law enforcement and public safety and in the armed forces. May you watch over them and give them hope and peace. This is my prayer in the name of love. Amen.
Amen. Thank you, Senator. All right, ladies and gentlemen, we're going to hear three bills today, House Bill 208, House Bill 77, and House Bill 61. We're going to begin with my friend, Chair Lady Lynn Smith. When you want to come on down, you can either sit here, you can go to podium, whatever you want. Just want to make sure the millions of people at home are watching to see your smiling face. To everybody who's in the committee, this is LC 394766. This is a conglomeration of license plates. Thank you, Chairman Payne, for keeping me honest here. As we typically do, none of these are controversial at all. I think they're pretty straightforward, but I'll turn it over to the bill's author to just take us through real quick.
Thank you, Senator and members of the committee. Thank you for your time this afternoon. I have before you House Bill 208, committee substitute from the House, and the committee substitute from the House was to incorporate both the Shepherd Center and the Georgia Veterans Service Foundation in this House bill, which is supporting state parks and historic site divisions and the enhancement of the black bass population. The reason the black bass is there is that Georgia is the #1 fishing spot for everyone with black bass fishing. It's kind of a fun story to tell, but in 1932, a person named George Perry caught a 22-pound, 4-ounce bass. And anybody who's ever been fishing knows what that means. So
Is that a fish story?
Yes,
Okay.
But there's no lure aligned. This is, it is really a wonderful way for the state of Georgia to give our citizens a chance to be spokespersons for something that they're very passionate about. And I'm obviously known for my love of the state parks, but I equally care about the Shepherd Center and our black bass and our veterans. So thank you for your consideration. I think we have a 5-star bill here.
I like the way you think. I like the 5-star rating. So for the committee members, again, just to remind you, not uncommon for us to take license plates and put them together again. I don't think anybody should be concerned about the ones that are in here. I do want to mention specifically, though, we learned through this process something that I did not know, which when we had a veteran's license plate for a disabled veteran, we're actually giving them 2 license plates per vehicle, even though we only require 1 in the back for Georgia. So what we've done here is made it that they'll only get 1 license plate per vehicle moving forward, but certainly, whether that be a car or a motorcycle, we want our veterans, especially those who have served and sacrificed us, to have that ability. But it seemed to be inconsistent with all the other license plates that we happen to have. So I want to make sure everybody understands that, and you're going to see that beginning on lines 22 in the bill. And then you'll continue down to Section 2, just to let everybody know. Just want to make sure everybody understands the substitute Chairwoman Smith about how that works for the license plates, again, for the motorcycles, all the way through. And then you'll get to Section 3. And 4 is for the Shepherd Center. Abigail, we are glad to work with Shepherd Center for the great work that they do. Thank you for your hard work. Did you have any car wrecks on the way here today, or are you safe? Okay, she was safe. All right, that's reason enough to go forward. And then our other ones, you'll see here, Georgia Southern University alumni, Delta Sigma Theta sorority. We also, obviously, you already mentioned the big bass plate as well. So I think there's good stuff for that in our DNR. Any questions from the committee members? Seeing none, do I have a motion from Senator Jackson?
I make a motion to pass.
I've got a motion to pass. I got a second from Senator Wicks. Is there any further discussion from committee members? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Passes unanimously, and I believe I'm carrying that for you. Is that right?
Thank you so much for that honor. I hope you catch the next big largemouth bass.
I hope. I'll take a 3-pounder. Thank you so much. All right, help us with some bills over there in the house, would you? All right. Okay. All right, next up, we're going to hear House Bill 61. If we could get Representative Seabaugh to come on down. As he is getting himself prepared, I know we've got some folks signed up to speak on this bill. We are going to also have Senator Still join him. Thank you very much. We're going to hear testimony on this bill today. We have found that there is a couple of technical cleanups that our esteemed legislative counsel, Kate, has found for us. So we are not going to take action on this bill because there are in a couple of sections where the sections were actually just inaccurate. We have to correct those, even though the bill is going to be substantially the same, that we will meet again on Friday morning. So just want to let everybody know that. And then another tee up for Representative Seabaugh. He's been a champion for anti-squatting bills. I want to take a moment and commend the great work that he did last year, really passing the substantial changes that we're seeing today and getting effects, although we still have some significant challenges. In fact, he and I are in the Cobb County delegation together. I had to help numerous people over the off-season throughout the summer and fall with significant squatter issues that still persist. And for those that are not aware, there actually are entire websites dedicated to people who want to be squatters, to download phony leases, what to do to talk to people, how to navigate the system for the longest possible time before they are evicted through the process. And we do not want that. And the same point, we don't want somebody who's duly paying a lease or rent to be kicked out of the place that they are paying. There's always a healthy balance. I will look down to some of our other states south of us and others that have tightened those laws down to a point where now squatters don't even come there anymore, because they know that it is not a squatting-friendly state. And I appreciate the work that you're doing. So we've got a substitute in front of you. I'm going to turn over to you. And for all the folks here in the committee, that is a new LC number. Let me just get the right one here. We should have LC 481597S. And I'll turn it over to you, Representative.
Thank you, Mr. Chairman and committee. It's great to be with you today. Last year, we did make great strides in passing squatter reform, and it passed both houses with 100% bipartisan support. And that legislation has made a big difference in squatting in Georgia, but also nationwide. We've gotten a lot of phone calls from other states about what we were able to accomplish. The bill before you addresses the growing problem of unlawful squatting in Georgia by providing property owners and law enforcement with clear legal tools to remove unauthorized occupants from private property. It defines unlawful squatting as a criminal offense, allows magistrate courts to adjudicate these cases, and outlines a process for the swift removal of squatters through a sworn affidavit. The bill also protects innkeepers, clarifies criminal trespass laws, and introduces penalties for fraudulent occupation claims, including forgery charges. It ensures law enforcement efficiency, officer safety, and property owner rights while limiting liability for lawful removals. I can go through this quickly by section. There's only 7 or 8 sections here. So Section 2 clarifies the magistrate court's jurisdiction in these cases. It allows magistrate courts to handle cases involving unlawful squatting in addition to certain other misdemeanors, and it expands access to justice and speeds up case resolution. Section 3 expanded the criminal trespass definition. It updates the definition of criminal trespass to include vehicles, aircraft, railroad cars, and watercraft. And it provides law enforcement with broader authority to address modern trespassing issues. Section 4, the offense of unlawful squatting. It establishes unlawful squatting as a misdemeanor. It allows property owners to file an affidavit to initiate law enforcement removal within 10 days. It limits liability for lawful removals and imposes restitution based on fair market rent. Section 5 deals with forgery related to squatting. It creates a felony in the second degree for forging documents related to squatting or in overstays. It's punishable by a mandatory 1 to 5 years imprisonment without probation or suspension. And Section 6 deals with the detention by property owners. It permits property owners to temporarily detain squatters or trespassers pending law enforcement response. It expands existing definition rights beyond retail businesses to include private property owners. And Section 7 deals with the innkeeper guest removal. It allows innkeepers to remove overstaying guests after a valid written contract expires using the same affidavit process. It authorizes the use of off-duty officers if sheriff deputies or resources are limited, and it limits liability for property damage during lawful guest removal. And Section 8 is the dispossessory proceedings and officer safety. It allows landlords to hire off-duty certified officers, which they can already do. It just reiterates that. And they can also execute writs of possession if the sheriff's office is delayed in doing that. It requires advance notice for officer safety and coordination and ensures eviction enforcement is timely and safe. And that's a 10,000-foot overview of the bill, and I'm happy to answer any questions. And if my colleague,
Senator Still, would you like to add anything to the presentation of the bill?
Thank you, Mr. Chairman. No, just want to thank you all for the opportunity to speak to it. I'm here to answer any questions on Section 7 or 8, if there are any.
Fantastic. And I want to thank both of you all for working with me, as well as the Georgia Sheriff's Association. I know Mr. Mike Mitchell's here, and he will comment in support of the bill. PAC, Robert Smith, the Prosecuting Attorney's Council, the numerous associations, I know many are here today that are going to speak on the bill, from hotel, lodging, retailers, et cetera, and the Small Business Owners Association that have also come. And I know we'll hear from some testimony in a moment, but I want to thank the interested parties that came together to work on that in collaboration. When we collaborate, things always come out a lot better. So, that in mind, questions from the committee members before we hear testimony? And we do have a fair amount of people signed up, so we're going to have to move briskly. I've got a question from Senator Jackson.
Yes, thank you, Mr. Chair. Just really quickly, can we look at can you talk to me about your changing the definition of criminal trespass? Can you speak to, I understand that it's adding railroad car, aircraft, watercraft, but can you speak to this piece of there not having to be any warning given? Or, I mean, it sounds, the way I read this, for instance, if I'm walking down the street and my dog poops in somebody else's yard, the way I read this, just by virtue of me going onto that property, I could possibly be charged with criminal trespass, because it reads to me as that broad, and so I'm just
And
wondering
Senator,
if you could
would
speak
you
to
cite
that.
the lines you're on for?
Yes, I'm sorry. Well, I have two different copies of it. I think it's line 67 through
Okay.
69.
All right.
Thank you. Line 67 through 69.
Did you say 167 or
No,
67?
just 67.
67, 69. That's the top of page 4.
Yeah, the intent there is for somebody that is staying on that property, not somebody that's just passing through the property, but somebody that takes up residence. If they're asked to leave and they refuse to leave, then they could be charged with criminal trespass. That is not the intent, is to start locking everybody up. The intent is to return the property back to the appropriate property owner.
Right, I understand your intent, and that's what the traditional definition of criminal trespass is that if you're asked to leave the property and you choose to stay, then that's criminal trespass. But this reads to me as being much more broader than that, and so that's my only concern about this section, is that it opens us up to criminal trespass charges for a lot of people that I don't think you intend to.
Okay.
I'm not reading it the same way. I hear what you're saying. Obviously, if somebody is, doing that, well, I mean, walking dog, or you're cutting across somebody's backyard, that's a lot different than somebody who's taking up residence there and doing that. I'm going to look over to our esteemed legislative counsel, Kate, to get her opinion, though.
I mean, I can see where it can be read both ways, and I'd be more than happy to
Okay.
tweak the language to
All right,
to
perfect.
match the officer.
All right, excellent find. Thank you, Senator.
Thank you.
Thank you,
All right.
Senator.
Other questions from the committee members prior to hearing testimony? All right, we're going to hear from a few folks. So let me tell everybody what the rules of testifying here in the committee are. First one is, if you didn't fill out the entire form, which we're going to put back out in a second, we can't hear from you because we need all of your information. Notice a lot of you did not do that. And when we come up here, we will have a good, professional, and polished conversation. The questions go one way. We ask questions of the folks testifying, not vice versa. And for the audience, it is a chance for you to listen. Please, we do not comment or boo or applause. And last but not least, we are going to have a fixed amount of time for everybody. So I noticed that they've got 1, 2, 3, 4, 5, 6, 7 or so people that look like they signed up all together. I would need for you all to come and fill out the rest of the form for me, who did not, as well as you might want to consider pooling your thoughts and comments. If you're all going to come up and say the exact same thing, you're going to take time away from everybody else. So with that in mind, we're going to begin first with Betsy with the Georgia Realtors. Betsy, why don't you come over here to the podium so all the folks back home can see your smiling face. And I'm going to put this right back out front. Again, if you did not fill all the blanks in, please fill the blanks in for me real quick. Thank you. All right, introduce yourself even though we know you and tell us who you're with.
Hi, everyone. Betsy Bradfield with the Georgia Association of Realtors. Just wanted to come before you all and say that we were really involved with this squatters legislation last year and getting it established and getting it off the ground. And as I understand it, this is just tightening up what we did last year and making it even stronger. So we are in full support of the bill, and I will stand for any questions you may have.
Thank you, Betsy. We appreciate all that you do and your association, obviously a big part of Georgia. Are there questions from the committee members for Betsy? Okay, wow, you did so good. That's fantastic. Thank you so much.
Thank you, sir, and thank you to Representative Seabaugh.
That's great. Mike, if you don't mind, Mike Mitchell with the Georgia Sheriff Association, will you just take the podium for just a moment here and just tell us about the work that was done on the bill and where the sheriffs stand?
Absolutely. Thank you, Mr. Chairman, members of the committee. Mike Mitchell, Georgia Sheriff's Association. Mr. Chairman, Representative Seabaugh, I just want to commend you for bringing this. Thank you for your work in this space. We think that this is a very simple, straightforward bill that will bring some solutions to the problems that we have. As this bill is currently written, it will allow for the immediate removal of an intruder or a squatter. So we're happy about that, and we would ask for your favorable support.
Thank you, Mike. I appreciate that. And again, I want to thank you, Terry, and your board and team for working with Representative Seabaugh and myself and Ledge Council as we work through this process to make sure that it fit well within those boundaries. So I appreciate it. All right, we're going to give everybody just another minute to check the forms, and then we'll hear some more testimony. Again, let me recommend for the folks that all signed up that might be against, I saw like 6 or 7, that you might want to think about if you're all going to say the same thing, pooling that between a couple, 2 or 3 people to make sure you get your message through. We do want to hear from you, but we don't like to always hear the same thing over and over again. Certainly. Senator Jackson.
Thank you. I'm looking at section 5 around the forgery offense. Is this trying to capture the people that run the websites that you were talking about, or I don't know enough about squatting
Sure.
in order to understand like
Yeah, so let me-
where's the forgery involved in this?
I'm glad you brought that up. There are, I've actually did some research when I found out what happened. I'll give while people are filling out the form this story. I got a call from neighbors in East Cobb, and this is a $1.5 million a house neighborhood, and the couple had moved up to New Jersey on a temporary transfer. They were going to rent their house for a year or two, hoping they get to move back to Georgia. Well, in the process of that, they put it up for rent. One night, in the middle of the night, people heard a bunch of cars, and folks moved into the house. They spray painted all the windows black. They put 2 big dogs out front and started a bakery business, which was open from 10 p.m. to 4 a.m. Thursday through Sunday. I think we can all connect the dots on what's happening. Then they started to Airbnb rooms inside of their house that they were squatting in to other people. What they did is, I did some research. There are websites out there that's kind of like a squatter's kit. You download a phony lease, right, that you can then fill out. In this case, if then they had signed it, et cetera, then they committed forgery by signing a phony lease that the squatter would. They give them a whole set of things of what to do. If the neighbors knock on your door, if the police come, it's literally an entire workflow process. It's actually amazing that someone spent this much time doing that much bad in order to get to where they are. And then they actually will then put different states, they rank them on how easy or how difficult it is to be a squatter. So it's quite amazing. And if you're bored this weekend, Senator, you want to get some good time, I'd encourage you to
I've
take a
got
look.
a 4-year-old, so.
You'll be fine. So hopefully he won't be squatting in his crib. So. All right, I'm going to grab this sign-up sheet here. Okay, first up, we're going to have Klaus with the Fulton Marshal's Office.
Department.
Yes,
I beg your pardon. I apologize for my chicken scratch.
You don't need to. It's all right. If this doesn't work out for you, you could always be a doctor. So,
You honor me, Senator. Thank you, Chairman. Thank you, ladies and gentlemen. I regret to say that I have been authorized by my agency to oppose the passage of this bill, at least in the current form. My primary concern lies in the fact that it lies in 16721.1. The procedure that is described in the new paragraph 2.
could you give us a line number of where you are, please?
Forgive me. Commencing at line 78 and ending at line 85,
All
fourth
right.
page.
Okay.
Thank you. Okay, the procedure that this seems to envision is that a person, hopefully a lawful, either a property owner or a person who has lawful possession of the property, executes an affidavit saying, "Hey, I'm the owner. I have lawful possession. There's people in there who aren't supposed to be there. They don't have my permission. That I've asked them to leave and they haven't left." The problem with this is that it goes straight from an affidavit being provided to a law enforcement officer, to a peace officer, and then to the peace officer putting the person out, simply saying that they have 10 days to do so. There's no opportunity, as has been seen in the current version of 16721.1, the squatter statute, for a person to file any kind of a defense. 3 days with the police chief, as is envisioned in the current version of 16721.1, or for that matter, 3 days. They have 3 days to file a counter affidavit, as it is under the ejectment procedure found in the 44 code. So theoretically, I'll just begin by saying this. I've been in law enforcement for 26 years. The one thing that hasn't changed, many things have changed, many things haven't changed. One of the things that hasn't changed is the sovereign citizens, folks who will use all manner of scheming and paper terrorism to take people's property away from them. Imagine some sovereign citizen who just wants to who just wants to harass a law enforcement officer, files an affidavit saying my property is being occupied by squatters. I'm not home. Deputy sheriff shows up with the affidavit. The deputy sheriff is proceeding in pure good faith, and he is on the side of the angels. Knocks on the door. Who should answer the door? My wife and our little daughter. First thing she thinks, "Oh, deputy sheriff, what's up?" "Well, we have an affidavit that says you're a squatter, ma'am. I'm afraid we're going to have to ask you and your daughter to leave." She would be put out of the house, which we own, subject to a small security interest by Wells Fargo Bank, for 20 years, and she would have no opportunity to raise a defense. The opportunity to make some sort of a counter affidavit is embodied in the ejectment statute contained in the 44 code, and that sucker is over 170 years old. Likewise, the previous version of the squatter statute, or the current version, I should say, of the squatter statute, also allows an opportunity to make a defense and say, "Whoa, this isn't, officer, it isn't what it looks like." One of the things I always say, I teach at the police academy, and I say, usually it is.
We're going to have to keep moving.
Sorry, I apologize. Usually it is what it looks like, but sometimes it really ain't. And we need to address the situations where it ain't what it looks like, so that law-abiding people aren't put off. I apologize for going on.
It's okay. Thank you for your comments. Questions for Klaus? All right, thank you so
Thank
much. All right, next up, Lindsay Siegel, I think that is. I may have butchered your name. I apologize if I did. Oh, all right.
Thank you, committee members and chair. My name is Lindsay Siegel. I'm also testifying in opposition to HB 61. So I'm part of the team that represented the residents who sued Efficiency Lodge, and I argued the case from the DeKalb Superior Court all the way to the Georgia Supreme Court. So I'm very familiar with the issues related to innkeepers and tenants. So this, for those of you who aren't familiar with it, it's a 2023 case that established essentially that an extended stay who's allowing families to live there for years can't just kick them out with no notice. They can't rely on a contract that says they're week-to-week tenants to say you're out and put families out on the curb. So, you know, I've represented tenants for dozens of years. I represented those who lived in extended stays, and I think this bill would have unintended consequences that go far beyond the concerns that the bill's author have raised. You know, essentially, a lot of these extended stays are voluntarily allowing families to live there for years. And it's incredibly, it would create a humanitarian crisis to essentially say that those families get absolutely no notice before they're put on the curb and before all of their belongings, including their children's school books, their medications, all of the clothes that they own in the world, will be subject to this innkeeper's lien that this bill establishes. Frankly, it's terrifying to me, and I think that innkeepers are going to use this to abuse the process. Right now, under Georgia law, a true innkeeper can put a family out with no notice. They don't have to go through the dispossessory statute. They can lock the door. If somebody really is a guest in an inn, that's exactly what they can do under the current statute. So I don't think that this needs to be changed. I'm also concerned about the squatter provisions and the trespass. When I was at Legal Aid, we would have a lot of people call us, especially during the pandemic, who were terrified because they had signed a lease, they had paid sometimes 3 months in advance of rent, $5,000 and $6,000, all the money they had in the world, to rent a place. They'd meet somebody over there, they'd get the keys, they'd view it, they'd say, "This is great, this is perfect for me and my family." And then 2 or 3 days later, somebody would knock on the door and say, "You didn't rent from us. We're the owners of the house." This is a victim of a crime. And what you're essentially saying through this bill is crime victims are now going to be further prosecuted just because they were taken advantage of because they replied to a Craigslist ad or something. Those are the people that are going to be impacted by this because the scammers, the ones who posted the property and changed the locks, they're long gone. What we should be doing is prosecuting those people, going after those people who are scamming our poorest and most vulnerable citizens, not the people who've been taken advantage of and think that they have a legitimate lease. I'm very scared about that part of it.
Lindsay, I appreciate your comments. Just 2 things. If someone does not pay their rate to stay at a hotel or motel, do you believe they have a right to stay there?
If they have been living in the property for years, as my clients were who sued Efficiency Lodge, they should have a right to the dispossessory process. I don't think they should have a right to live there without paying, but the dispossessory process provides a means of getting the property back if you're the property owner who's allowed somebody to live there for years, who's stopped getting rent. One of the things that we heard in Efficiency Lodge, and one of the claims that our clients made, is that the property manager who, you know, this is not a professional property manager in every case. Sometimes this is just a person who lives there and is doing this on the side. The property manager is stealing their money. So they were paying their rent in cash, the property manager is stealing their money, and then if they complain about some kind of conditions that are bad at the property or they do something that the property manager doesn't like, the property manager says, "Oh, suddenly you haven't paid your rent." And that happened. And so the current statute allows for a process where if this tenant truly has paid their rent, they can go to court. And the property manager can prove that they
I would have to disagree
didn't.
with you on a hotel or a motel being very different than an apartment. But I think the other thing you mentioned that concerns me is I agree if someone was scammed, they went and they put a deposit down or 3 months in advance, they are absolutely, they have been a victim of a crime. I agree with you. But there's another victim of the crime. The person that owns that place. And I think you're forgetting that in your comments and equation, because if I'm the one that owns that house, that I have to pay the taxes, utilities, and the mortgage, et cetera, and now I can't get into that rent, I'm as much as a victim as that person is. And that's where I think we get lost in this. And we have to remember there are actual property owners and small business owners being impacted every day. I think you're going to hear some very enlightening stuff from some of the small business hotel owners where that literally has tipped some of them upside down. So,
You mind if I respond to that last part?
in 10 seconds or less, go
Okay.
ahead.
The issue is that you're right, that there is a victim in the person who owns a property, but under the current squatter bill, there's a process, and it's a very fast process to get that person out who doesn't have a right to be there. This bill makes them an immediate perpetrator of a crime and gives them no notice and no opportunity to say, wait a second, I have paid months, I've paid my entire life savings to live in this location, and I should have a right to at least go to court and explain that to a judge.
Thank you. All right, next, Layla. Oh, boy, that's tough handwriting, sorry.
It's missing a couple of vowels.
Okay.
All right, my name is Layla Prudecha. They're chairman and members of the Public Safety Committee. My name is Layla Prudecha, and I serve as the CEO of Gwinnett Housing Corporation, a nonprofit organization dedicated to developing affordable housing. I am here to submit my comments and urge you to vote against HB 61. During my 5-year tenure on the Georgia Department of Community Affairs Homeless Continuum of Care Board of Directors, I became keenly aware of a significant gap in the housing policy. Families living in extended stays hotels are not classified as homeless under the HUD definition, rendering them ineligible for federal assistance. They're also not counted in any of the official homeless counts. In 2019, as part of the Georgia Initiative for Community Housing, our team conducted a door-to-door study across 12 extended stays in Norcross. Our findings, which were later corroborated by other jurisdictions in Metro Atlanta, revealed that 84% of the respondents consider the extended stay hotels their primary residence. These were not transient families. 75% had lived in the same extended stay for more than 3 months, and 20% had been there for over 3 years. Despite my experience in the housing industry, I was shocked by the conditions these families endure. I witnessed young children doing their homework on the dirty floors of a 200-square-foot room, boys sitting along in a corridor with headphones and a tablet, likely seeking relief from cramped living quarters. Our research found that 40% of the household interviewed had children in the household. Although no comprehensive statewide survey has been conducted, available data highlight the scale of this issue. In Gwinnett and Clayton counties alone, over 110 school buses transport children from extended stays hotels to school daily.
Ma'am, I appreciate the statistics. While they're very important, we're talking about the actual language of the bill right now. We're going to have to wrap up in the next 30 seconds.
I was trying to show that they're not squatters, that there are actually vast majority of the extended stay rooms are indeed, and this has been well documented, occupied by families who live there. I will wrap it up if you're not interested in statistics. I'll say that no one is suggesting that these families who live there should be permitted to remain in the extended stay hotels without fulfilling their financial obligations. However, without the due process protections granted to traditional renters, we risk witnessing more devastating tragedies, such as the recent case in Detroit where 2 young children froze to death in a car while awaiting shelter. If HB 61 is enacted and current tenant protections are eliminated, the state will need to allocate significant funding to rapidly rehouse thousands of families with children who will inevitably become unsheltered. This has far-reaching community consequences. I urge you to consider the devastating consequences of removing these protections and to assure the families, not squatters, in extended stay hotels are granted the same basic housing rights as other tenants. Thank you.
Thank you, and boy, I'm lost on this one. Somebody scratched your name out. Last name Sibley, maybe? Okay, you have to help us with that one. It's hard to see it. I appreciate everybody talking about the difference. I want to make sure real clear. A hotel and motel is not an apartment or a house. We need to make sure we understand that, folks. Continue on. Please introduce yourself.
Sure.
And by the way, we're running low on time, so everybody gets 90 seconds moving forward, so keep going.
Okay. My name is Marielle Risner-Sivley. I'm the Director of Housing at St. Vincent de Paul, Georgia, and I'm also a Roswell resident, so I'm your constituent. Thank you for the time to speak with you today. We have a program called the Motel to Home program. We receive over 500 applications a month, and this is a hard-to-find application. It's not, well, you have to dig through our website to find it. And the people who are applying to our Motel to Home program are not traditional hotel guests. They know that, and the hotels know that. They've been living there. It's a place of last resort for them. Their families and their seniors. That's who we're serving, and we're getting over 500 applications a month. I agree that this is ripe for some clarification between being a hotel guest at, say, a Marriott for a vacation or a business short business and being someone who lives in a motel. But the current language of this bill, it's bad. It strips people of rights that they should have. And the extended stay motels, they know their business model, and it's a residency model. And so this is very ripe for clarification by you all to set forth a different standard between hotel guests and those who are living there as their primary residence. And we're helpful to provide recommendations. I'm an attorney. There's other attorneys here before you. We would like to be able to provide you with some other language that would give an amount of time. But simply one person writing an affidavit and then being able to call someone that they have the cell phone number to get this person out, that's not due process, and that's not anything that any Georgian deserves.
Thank you, and please send that information over to me, and this is Will Spencer next to me, as well as anybody who wants to send across any statistics or other information. We'll be happy to gather that, and we'll take it into context with Legislative Council, as well as make sure the committee members have it.
Thank you.
Thank you. All right, Elizabeth, come on down.
So, Mr. Chairman, members of the committee, my name is Elizabeth Apley. I'm here on behalf of the Georgia Supportive Housing Association, the Corporation for Supportive Housing, Presbyterians for a Better Georgia, and 95 Georgia. We oppose this bill. House Bill 183, which is the predicate for the provision regarding the innkeepers ejectment portion of House Bill 61, was heard that innkeepers testified extensively in the House Judiciary Committee, and the bill was unanimously tabled, even before we had a chance to testify against the bill. The squatting portion of this legislation proposes to undo what was passed by the House and Senate in House Bill 1017 last year that was carefully negotiated and reviewed and provides some notice and due process and distinguishes the unlawful squatter from the victims of a scam. This bill does not do that. In addition, if you look at lines 81, all that's required is an affidavit by a person. No facts are required, no evidence is required, and what it asserts is that the person is present, who is present is unauthorized. When you get to subsection B, it turns into unlawful. So you've converted what was unauthorized into what's unlawful without any meaningful distinction. In addition, the bill proposes to give unlimited right to detain an individual. So this implies and carries with it the right to use force in Section 7 for anyone with reasonable grounds to believe that someone has committed or attempted to commit the offense of criminal trespass, which, as you've redefined it in the bill, unreasonably expands to anyone entering property under any circumstances.
All right, we're going to have to wrap up. You're out of time here.
Okay. The critical part of my final remarks, Mr. Chairman, relate to what I have on the different subpart D in Section 7 that converts all people living in a hotel to a guest status, which provides for summary ejectment and lockout, which is already the law. What the Neeson decision by the Georgia Supreme Court decided in 2023
we're twice over. You're using everybody else's time.
is that it requires a factual analysis that considers the duration of the individual's stay and the intent of the parties in order to determine what's appropriate treatment.
Thank you, Natalie. Or thank you. I'm going to bring Natalie up next.
Natalie Kaiser, Executive Director of House ATL. Thank you for the opportunity to be heard. I'm speaking in opposition to the innkeeper portion of this bill. I would like to share an example which I think illustrates some of the legal descriptions that you've had. A mother I know called me because she had complained at her extended stay hotel about the electricity being off. She'd been at the hotel for 18 months. She paid $365 a week, more than $1,400 a month. As a result of her electricity complaint, they told her they would not accept her payment for rent for the next week. This was on a Friday night, so on Monday morning she would have to be out. There was no staff for her to speak with over the weekend. I went to the hotel that Monday morning and stood beside her as she pleaded to make her payment. Instead, they sent the maintenance staff to the room to remove all the furniture, the stovetop, and the mini refrigerator, and leave her, her son, and the dog sitting on the floor with nothing. She had no vehicle. She was staying next to the restaurant where she worked at the Extended Stay Hotel. Her son's school is nearby. Managers of extended stay hotels can treat their customers this way because there are so many customers right now. They don't have to worry about treating people well because our housing supply shortage, as those, I know y'all understand economics, has created an endless stream of people for their business model. If you've been paying high rents for 18 months, you should be treated as a tenant. An apartment that has, a place that has fewer amenities than a studio apartment. Should an essential worker, a parent, have no recourse when a landlord just decides to end their weekly agreement after months or even years of paying rent? It should be considered rent after such a long period of time. Should they be treated like they have done something wrong and have their belongings placed on a curb in the way this bill currently indicates?
Okay, Natalie,
I don't
you're
know if you
using
noticed
everybody
that.
else's time out now. You're going to have other people who can't speak on the bill.
I'll wrap up, sir.
Thank you.
Thank you. I think Georgia taxpayers should not be seeing their taxpayer money go to first responders and asking them to treat our citizens who are paying as customers in this manner. Thank you.
Thank you. Okay, next up, Ryan Ahoa. Are you coming with others or by yourself?
By myself, Mr. Chairman.
All right.
Good afternoon, Mr. Chairman and members of the committee. Thank you very much for the opportunity to speak before you today. My name is Ryan Albers. I am a Senior Manager of State and Local Government Affairs for the Asian American Hotel Owners Association, better known as AHOA. AHOA is the world's largest hotel owners association in the world, as well as in Georgia. Our members own 67.7% of all the hotels here in Georgia, which equates to 1,501 hotels or 127,063 hotel rooms. To say our members are having issues removing guests who do not pay would be putting it lightly. Within 24 hours of making a request for information from our members, we received 190 responses. Within our internal poll, we gathered 272 responses from members that represent over 700 hotels in the state of Georgia. Of all the responses, only 8 of those 272 said that they did not experience an issue with squatters at their locations. I'm going to reiterate that. Only 8 out of 272 said that they did not experience this issue. Furthermore, these issues happen in all types of hotels, not just the extended stays, as it might have been made to heard. 49% of our respondents stated that this happened at their non-extended stay hotels, and 8% only said that it happened at extended stays only. 43% said that it happened both in an extended stay and a non-extended stay type of hotel. For our members, guests refusing to leave is extremely detrimental. The majority of our members own limited service hotels that are solely dependent on guest occupancy for revenue. They do not have restaurants, valet services, or any other services of the like that could offset this revenue. When a room is occupied by an unpaying guest, it is extremely detrimental to their bottom line as small business owners and operators. We believe that this substitute will help protect our industry and our owners and operators, and we respectfully request a favorable vote today.
And you have folks with you who are small business owners, a part of AHOA, is that correct? Would you all
Yes, sir.
just raise your hand back there? Thank you for being here. I know you're taking time away from your businesses. All right, thank you very much. Next, I've got Graham Younger with Gactyl. Remember, we got short time here, folks, and then we're going to be wrapping up with Chris Hardman.
Understood. Thank you, Mr. Chairman. My name is Graham Younger. I represent Gactyl. I also have, and he does not need to testify, but a criminal defense lawyer of the week in Russell Gabriel, if there are any questions here. I would like to specifically talk about lines 67 to 69. You took a look at them very briefly. I believe that the ripple effects, I think, of changing, aside from traffic offenses, maybe the most common offense that our lawyers see every single day, could be exactly what was suggested here a moment ago, that picking up after your dog, selling Girl Scout cookies, maybe even knocking, political canvassing door to door could all be criminalized by this. In changing that offensive criminal trespass. And what I was hearing, I think maybe from the bill's sponsor here, and I don't want to speak for you, is that if the goal is to make sure that we are working on this situation where someone is entering and then not leaving, that within, in Section 3, B2 and 3, allow to sort of create or keep the crime of criminal trespass both prior to entry or after receiving notice that from the owner of the property that they cannot be on the property. So my hope there is that as you take a look at this and before you do act on it, as council takes a look at it, that between sections 1, 2, and 3, there won't be a need for a section 4 here. And I thank you very much for the committee's time.
Thank you so much. All right, appreciate it. We're out of time. We'll have to do it next time. Chris Hardman, you're going to clean us up because we have to let our next bill's author have a chance to present his bill as well.
Absolutely, Mr. Chairman. I want to thank you, thank the members of the committee for hearing so much testimony today, but I also want to commend Representative Seabaugh and Senator Sean Still for your tireless efforts. This has been a multi-year effort from you both, so thank you both for what you're doing to perfect legislation that is so needed by our industry, more needed than just about anything else. I think the previous witness said it best. Just one quick survey, we found out that 3,500 instances where individuals refuse to pay and refuse to leave. That's simply because they're claiming tenant rights, and law enforcement has let us know that the legislation and the law is not currently clear. So they're having to go through the eviction process, which sometimes takes 15 months. What this legislation does is it brings clarity to an uncertain legal system, but most importantly, it provides safety and security for our hotel employees as well as the law-abiding guests that we serve. And I know, Mr. Chairman, in the interest of time, I'm going to wrap up with that, but we could have brought 250 hoteliers here today, but I know the time is short, so I would ask for this committee's favorable consideration on Friday for House Bill 61. Thank you.
Thank you very much, Chris. I appreciate it. So let's just talk about the posture where we are. I would like to ask committee members, obviously first and foremost, as well as some folks who have some suggestions to the bill, to get that information back to a team of people, which is going to be obviously the bill's author, Representative Seabaugh, Senator Still, myself, so we can get that information. We'll be working with Kate, our legislative counsel, in order to come up with a couple of little technical changes. Obviously, she found some issues in the bill that were just citing the wrong code section, which we need to get cleaned up. As soon as we have a committee substitute, just like we did early this morning, you got an email from us doing that. We'll get it out to everybody just as soon as it's readily available. Thank you all so much for your time in this. We are going to meet on, don't leave committee members, Friday morning at 7 a.m. All right, next bill up, we've got House Bill 77. Lehman, why don't you come on up, take a spot here at a microphone here, and let everybody know. We've got some suggested changes on this bill too, so this is going to be a hearing only, but I want to get testimony out of the way. And my guess is you probably have a friend on this committee who might want to help out in the industry. I'm not sure, so I'm looking over at somebody. He told me he'd be the last person to let me down. That's all I know.
Well, thank you. I know that time is short, and I really do appreciate you hearing this bill. I'll try to make it as fast as possible because I know that time is of the essence here, and I don't perceive this being a real controversial bill, to be honest with you. But I do have it's House Bill 77 is LC 394765S, and I don't know if you have that in front of you or if it's an amendment that we would need to be voted on or whatever. We can go on this, but I'd like to just share with this.
Let's just do the overview of the bill today because we're going to look at it and we'll do a committee substitute
Sure.
for a future meeting.
Sure, great. So just briefly, this bill came through the Senate before and got on the House, and it died there basically out of time. But I'm actually I'm glad that it did because we were able to tweak it a little bit and I believe make it better. But I believe this is an important bill for Georgia that needs to be addressed because there's a growing concern of a public safety issue that's happening. Traditionally, when I was growing up, when you have the funeral procession coming your way, you would pull over to the side of the road. In fact, I remember when I was a young kid, some people would get out of the car, and that's to show the respects. But that's not happening now. But more and more people are not pulling over on the side of the road, and it's causing issues. And my local sheriff and other sheriffs around Georgia have reached out to me and expressed that they're having an increased issue with the danger of their deputies as they give these possessions because they have oncoming traffic that's not pulling over, as well as some people are pulling over and they aren't, some people aren't, so it creates confusion within the population of the oncoming traffic as well. So what this bill does is basically clarify in greater detail what's expected, what a funeral procession is, and tries to eliminate any public safety issue that we might have going forward. I have the the approval of the Sheriff's Association behind it. Mike can attest to that. Also, Nathan Goldsby here of the Georgia Motors Trucking Association, who's in favor of it. In fact, we were able to work on it so much that I haven't found anybody that's against this bill, really, and that needs to see this happen as far as safety for their deputies. Mr. Chairman, that's the bill in essence. I'm happy to answer any questions you may have.
And I think it's a lot of common sense that's not so common these days. And I think people who have moved to Georgia, who are not maybe from traditional southern states where we take a funeral procession a lot more seriously, this would be a good reminder. And I hope we'll also work with our friends in driver services to make sure that we're educating those that are getting their permit and their license, or maybe even getting their licenses renewed, to remind them of this as well. I want to thank Terry Norris and Mike Mitchell with the Sheriff's Association, as well as Butch Ayers from the Chiefs of Police and his team for offering, I believe, some good feedback as well.
That's right.
To make sure, because we certainly want everybody to be safe, but most importantly, those law enforcement officers that are out there who are leading and making sure that procession gets through, that they are also safe. And talking to the Trucking Association, they brought up some good points about where trucks were perhaps in blind curves, to make sure that would be protected. So I believe you're going to see some of the language that Representative Franklin has put together. We'll make into a committee substitute to make sure it's nice and clean for everybody. Are there questions or comments from the committee members for Representative Franklin? Okay. With that in mind, we will do the same thing. We will work with Kate, Legislative Counsel. We'll make sure we have a committee sub that everybody's looked at. Certainly, again, the sheriffs and chiefs of police, to make sure that they're comfortable, the committee's comfortable. We'll get that out to you as soon as possible. That also will be on Friday morning at 7 a.m. We've started this morning at 6 a.m., so we're giving you a break going to 7 a.m., Representative Franklin. But we will have you up first because I believe you will be a pretty quick bill.
Thank you, sir.
All
I
right.
appreciate the opportunity. Thank you.
All right. Thank you all so much. This meeting is hereby adjourned.